This show furnished by Karl Gerber and Employment Lawyers Group.
Shift work.
Talk Radio 790 KABC. You're listening to the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber. I'm a real lawyer, and we actually have another lawyer and two kids in the studio tonight. This is the Bar Mitzvah episode of the Karl Gerber Workplace Lawyer Show. Yeah, 13 episodes. Wow. That's kind of weird. I don't know how that happened. So, yeah, this is the 13th show, and I wrote a lot of this show on Friday the 13th, so I hope this turns out okay. Since this is a show about equal inclusion, I guess this also has to be the Bat Mitzvah episode. And we have to think again. Ooh. Wow. So for those of you that don't know, 13th is a big year for initiation rituals in different cultures. And besides Judaism, there's a ritual in Brazil, in the Amazon. Yes, young boys belonging to the indigenous Sateri Maui tribe, and I have a feeling I mispronounced that. They mark their coming of age when they turn 13 by a bullet and ant initiation. Yeah, that's the tradition. They go into the jungle and search for bullet ants, which are sedated by a leader who submerges them in a herbal solution. The ants are then weaved into gloves with stringers pointed inwards. Yikes. An hour or so later, the ants wake up angrier than ever, and the initiation begins. Each of these Brazilian boys has to wear the gloves for 10 minutes. This sounds like a workplace injury waiting to happen. Enduring the pain demonstrates the boys' readiness for manhood, so few cry out when they're doing this because that would demonstrate weakness. Each boy will eventually wear the gloves 20 times over the span of several months before the initiation is complete. Wow. This show has grown into manhood, as we've established. We've gone from interviews of phone sex operators to former adult picture stars who believe their manhood has been infringed, to cosplay robots who are sexually harassed by doms on cosplay ranches that even double of ostrich farms. We've had former rink queens turned real estate brokers sued for restricted on-call and not paying a sexual harasser's commissions. Wow, lots of things on this show, and you can, of course, hear all these old episodes at workplacelawyer.org, or if you type in Karl Gerber ABC. We've also heard about a CFO obsessed with suing his employer for starting an international gay male groin-grabbing gesture that spread to Hollywood, which we later found out may have just been a mask for him to finally come out. Next week, you're going to get lucky because you're going to meet Remus Helms' brother. Yes, Remus Helms, that adult film star who claimed his male member was infringed and has been featured on a number of our episodes. His brother is going to come on and talk about age discrimination. Yeah, he's going to have a lawsuit maybe against a novelty toy manufacturer. But tonight, we're going to talk about work injuries. Work injuries. Of course, we have a guest in studio tonight to highlight the subject matter, and rest assured we won't be boring you with normal work injuries. We'll try to get into the topic of unusual work injuries, maybe repetitive motion injuries for webcam models, maybe back injuries motivated by twerking and prosthetics among strippers, something like that. Stress injuries for personal assistants of some really big-time people. So looking through the whole issue with work injuries, I did my usual research, and the U.S. Department of Labor says there are 1 million workers' compensation injuries a year out of 130 million workers. That's a lot. I found out that agriculture is the highest incidence of work injury. 13.6% of all work injuries are agriculture. Nursing, also quite high, 12%. And government, very high rates of work injuries. And Sef Krell, who's a real workers' compensation lawyer who I work with, is here in studio rustling papers. And he's going to talk a lot about these government injuries in a minute because they're very interesting. And I guess there was a story in the LA Times today about government work injuries. Police protection is also a very high rate of work injury. And people building homes, wherever they're manufacturing homes or real homes, have a lot of work injuries. So do people in veterinarian services. Steel foundries are big, correctional institutes, hospitals. Psychiatric hospitals seem to be a big place for work injuries. I've had a number of clients who work for psychiatric hospitals tell me that they actually get hit a lot by patients. And that's a very hard job. Hog and pig farming is also pretty big on the work injury list. So is heavy construction. So are pet supplies and mattress manufacturing. That's kind of weird. I don't know why that is such a high incident rate. Maybe it's a lung injury or maybe it has something to do with Remus Helms. I'm not quite sure. But luckily, law firms don't make the top categories for work injuries. That surprises me. And trunk and back injuries are very common. So now I'm going to introduce Mr. Sef Krell, who has been a workers' compensation lawyer for 24 years. He is certified as a specialist in workers' compensation. He is in Encino. I've worked with him for many years. I actually went to junior high school with his sister, if you can believe that. But at any rate, Sef, you're not the evil Egyptian thing. I know in that many of you maybe saw the King Tut episode down there at the Science Center. But Sef is the evil god of calamities, weather, and tornadoes in Egypt. But this guy here, he's not evil. He's a very good workers' compensation lawyer. Say hi to our audience, Sef.
Hello, audience. I have been known to cause a few calamities in my day.
He's also a surfer, and I think there was an LA Times episode where he actually was on there talking about surfing. But at any rate, I want to talk about workers' comp because it has a lot of crossover in employment law. It's also pretty important. And I think workers' comp is actually a good thing. People need to do it. It has low fees, and it may be the only remedy. I'd like you to talk a little bit about that.
About exclusive remedy in a workers' comp? Sure. So essentially the legislature decided about 100 years ago now in California that we would exchange suing employers. We would not allow people who got hurt at work to sue the employer directly unless the employer had intended to cause the injury or had acted in a way that was so grossly negligent that it was likely for injury to occur. And instead of allowing the employer to be sued directly, the state set up a system of workers' compensation, which was adopted from models from other states and from European countries. And really, it had to be set up because of the political backlash when there were great injuries or tragedies like the Coat Triangle waste fire, where about 130 people died, and there was no remedy for the employees. So the legislatures decided that in exchange for going suing the employer, you would be able to go to workers' comp and receive those benefits.
A lot of clients are turned off by workers' comp, and I'd like you to discuss that. First of all, it's a very low fee. It's much larger than any tort lawyer would charge in a normal employment case, right?
Right. Statutorily, workers' comp attorneys generally get a 15% fee. Some unusual circumstances, maybe you would get a higher fee of up to 18%. And perhaps in a death case where there were no issues and it was just a matter of awarding benefits, perhaps fees might be as low as 12%. But generally it's 15%. And since that's statutorily mandated, it doesn't really change.
Yes, those are quite low fees compared to, personal injury lawyers that want a third or 40%. And also I think you can get costs back too if you're in workers' comp, right?
There are costs that are reimbursable to the injured worker if you had to, let's say, hire an expert to help you prove up perhaps a loss of earnings claim in addition to your overall residual permanent disability. If you're not primarily English speaking and you need the services of an interpreter, those are costs that are reimbursed.
The other big thing that I see is medical treatment in workers' comp, and I think it's important to not necessarily be with the medical treatment the employer is providing. Can you explain how that works?
Sure. So generally now, when an injured worker makes a claim against his employer, the insurance companies and the employers have set up what they call medical provider networks or medical groups, and those groups are set up a series of doctors in all different specialties, which are the only doctors the injured worker is allowed to see. And if the injured worker, in an admitted claim, this assumes that the employer has accepted the claim, then the injured worker is limited to just those doctors that are on the group, and getting out of the group is sometimes critical.
Yeah, I've seen a lot of situations where there's a clinic, and the clinic has got somebody who may not even be a doctor. It could be someone else, and they're certainly not a specialist. And those people are not really qualified to diagnose the person. There's an injured person that may have a serious injury that's with this clinic for a long time, and the injury is getting worse, and it starts affecting other parts of their body.
Right. So the industrial clinics are oftentimes the bane of the workers' compensation attorney. You have a series of doctors and industrial groups that, although they are supposed to be looking out for the injured worker, sometimes it feels as though they really just serve as a rubber stamp to send the injured worker back to work with a diagnosis of something like a sprain or a strain.
I had a case where the woman had one injury. I think it was maybe an ankle injury, and we're not giving her any treatment. It just got so bad that the injury spread through her body, and she became permanently disabled, and I ended up winning her case. But those clinics can be a real problem if you're stuck with one. How do you get out of being with the employer's clinic? Is there a way to? And we're going to talk about that when we come back. But if you have a labor law question, please call me at 877-525-0700. That's 877-525-0700. 877-525-0700 if you have a termination case or a work injury, something like that.
Bonus opportunities galore. Many young men like their money and they all come back for more.
Since 1993, the Employment Lawyers Group has been a consistent force in fighting for the rights of California employees. They've represented thousands of employees in cases in which they've lost their jobs, been sexually harassed, discriminated against at work, or owed wages individually or as a group such as a class action. The Employment Lawyers Group has maintained a high win rate and a serious record before the California courts. Please call 877-525-0700 for an experienced work lawyer. That's 877-525-0700. They have call takers standing by. Online, research the firm at worklawyerca.com. They have offices throughout Southern California. If you hire the Employment Lawyers Group, your legal problem becomes theirs to solve.
That $1 in your pocket, it's worth more than you think. Because at Wendy's, $1's all you need to pick up the new Buffalo Ranch Crispy Chicken Sandwich. Hey, you deserve the most bang for your buck. Now you got it. Hot, crispy chicken topped with melty Monterey Jack and creamy Buffalo Ranch sauce. With this much flavor in one sandwich, $1's worth more than ever. The $1 Buffalo Ranch Crispy Chicken Sandwich. More flavor, $1. For a limited time at Wendy's.
At participating Wendy's, price and participation may vary in Alaska and Hawaii.
Say no to rising prices. Amazon is raising its Prime membership price from $99 to $119 for free shipping. Walmart offers free 2-day shipping with no membership fee. That's $119 back in your pocket. What would you do with it? Go to WalmartFreeShipping.com for the chance to win a $119 Walmart gift card. That's WalmartFreeShipping.com for complete rules and details. Walmart, 2 business day shipping. Minimum $35 order. Restrictions apply. Say no to rising prices. Amazon is raising its Prime membership price from $99 to $119 for free shipping. Walmart offers free 2-day shipping with no membership fee. That's $119 back in your pocket. What would you do with it? Go to WalmartFreeShipping.com for the chance to win a $119 Walmart gift card. That's WalmartFreeShipping.com for complete rules and details. Walmart, 2 business day shipping. Minimum $35 order. Restrictions apply.
Amazon Prime Day returns July 16th. It's an epic day and a half of our best deals. So whether you're looking for flat screen TVs or footwear, headphones or kitchenware, beauty products or home furnishings, you'll find tons of amazing deals on brands like GoPro, Sony, Adidas, and more, all in one place. Don't miss Amazon Prime Day, starting 3 p.m. Eastern on July 16th through July 17th. Not a Prime member? Start your 30-day free trial today.
Shift work, hard work,
Talk Radio 790 KABC. You're listening to the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, a real workplace lawyer. In studio with us tonight is Sef Krell, who is a real workers' compensation lawyer. In fact, a workers' compensation specialist. He practices in Encino. And we have my sons in studio. Stephen Gerber is helping a live stream. So now listeners of this show can listen to episodes on YouTube, Facebook, Twitter, places like that, like a lot of modern people do. I know the show before me has a lot of people that listen on that streaming. So very exciting. And my youngest son is observing. Before we broke, we were talking about work injuries and the fact that workers' compensation may be the only remedy sometimes, and it has very low attorney fees, so it is in the employee's benefit. There's something called workers' comp exclusivity, which to me is a bad word because it means that I can't pursue the case for tort. And usually if someone wants to say they've got intentional infliction of emotional distress claim or a reckless infliction of emotional distress claim, you get these arguments it's preempted by workers' comp. Sometimes you get that on assault and battery. And it's not. There's case law saying it isn't, but that's been the fight for me. We also are talking about medical treatment and workers' comp, which is a really big issue. You don't want to be stuck with the company clinic. Seth, you told us about something called an admitted injury case. Maybe you should explain what admitted and non-admitted means to the listeners in workers' comp.
Okay, so to begin with, if you're on the admitted injury track, that means that, you fell off a ladder, you broke your arm, it was observed by witnesses, and generally in that instance, the employer, assuming that they have workers' comp insurance, they're going to provide you with a claim form and send you to the appropriate type of medical specialist within a reasonable period of time, sometimes as little as 24 or 48 hours, 72 hours, depends on the nature of the injury. If the employer tells that injured worker in an admitted case that we are going to provide care, and here's a list of the group of doctors, then an injured worker who's on his own, not represented, sort of, for lack of a better term, at the mercy of an insurance company, doesn't know who the doctors on the list are, doesn't know if those doctors are going to be sympathetic to them, or it could be just Kaiser. And, in a situation like that, the injured worker is not likely to be able to get the medical evidence that they need to later prove their case.
Is there a way that you can go to your own doctor if you have a work injury?
There is. It's rare. Injured workers would have to pre-designate at the time of hire or at the time that they're notified of their medical provider rights. That would be one instance. The other instance is in a denied claim. Denied claims are just what they sound like. Employer doesn't witness the injury. Employer doesn't believe the injury. Employer wants more medical evidence before they'll admit the claim. And in that instance, within the delay period, the employer is supposed to pay for up to the first $10,000 of medical treatment, which should be an incentive to doctors to want to take on those cases, because that first $10,000 is out there to be paid by the insurance. But the way that insurance companies have cracked down on doctors collecting their money has really limited the number of doctors who injured workers can be sent to outside of a medical provider network, unless your attorney is familiar with the area where you live, the providers that are either on the medical network if you have to use them, or there'll be doctors who will see those injured workers on a lien, and then those doctors expect to be paid by the insurance carrier later because the injured worker only receives. That's a critical component.
Yeah, I'm also thinking if you just kind of go through your own insurance, your insurance may say, we don't really want to cover this because it's a work injury.
Well, that's an interesting concept. With the Affordable Care Act, you would think that whether or not it was a work-related injury, if it was being denied by the workers' comp carrier, that you would be able to go through your private health care. And oftentimes, injured workers, with guidance of their workers' comp attorney, will have to use their private insurance because there's no other remedy.
So I get a lot of calls about work stress, and I understand that there's technically no such thing as work stress and workers' comp, but if it's a sudden event, like, for instance, a robbery, someone is traumatized, I think there's a claim for that. Sexual harassment or race discrimination, can that also have a workers' comp component to it?
Sure, absolutely. So a little bit goes to exclusive remedy, and a little bit goes outside of exclusive remedy. If you have those events where it's a hostile work environment that includes, let's say, touching or something along those lines, then not necessarily just an exclusive remedy. You could pursue your workers' comp claim and also pursue a civil claim. But with respect to the other part of your question, whether or not, let's say, an injured worker wants to proceed just through workers' comp, that's certainly viable.
I'm seeing some situations where I have to say it's very important for employees to be working with an attorney like me who is in connection with someone like Sef. If the employment lawyer for the discrimination or wrongful termination case is not working hand in hand with this workers' comp lawyer, it's a disaster on many fronts. One of them is you see these attempts to waive the $300,000 claim for sexual harassment through workers' comp. I had that happen once, and we had to fight to get that turned upside down. It was a workers' comp lawyer that really wasn't paying attention and was offered, $500 for a sexual harassment claim that I got well over $300,000 on, maybe even 12, 13 years ago. That's one issue. The other issue is there are inconsistent remedies. What I do for disability law means if you've got a disability, you can be reasonably accommodated. And that means that you can either have, schedule changes, device changes, all that, or you can have a leave of absence. A leave of absence to treat medically is a reasonable accommodation. But in workers' comp, there may be somebody trying to say, I'm really out. I really can't work. I'm really damaged. I need to be out 4 years. And once that happens, there's certainly no claim anymore for your FMLA for 12 weeks. And, 4 years is a long time. If you want to come back to a company after 4 years, the job may not exist, the department may not exist, they may not even be in that location anymore. And so it just doesn't work so well. And I think it's very important that the workers' comp guy or lady and the person doing the employment claim for the job loss is really in sync on this, because you can really get in a situation where the employee is just really not getting the right legal representation. The other thing that bothers me is several years back, you can't have a wrongful termination case anymore if you're fired for a work injury. If you have family medical leave, you have in a company where there are 50 employees or more in a 75-mile radius, you've been there a year, you have a serious medical condition, you got your FMLA, you can be up 3 months, and they fire you for that, you have a wrongful termination case. If they fire you because you have a disability, it's also wrongful termination. But you can't sue anymore if it's one of these work comp injuries, like a broken leg that's better. I don't know, maybe, you have a clerical job, you can go back to work in 2 weeks. And I think that's really unfortunate, because one of my cases that I tried, I got over $500,000 when they fired the woman for workers' comp, and there were a lot of those. And I do want Seth, when we come back, to explain what 132A is, because I think a lot of employees don't understand it. I know a lot of workers' comp lawyers don't even want to do it, but that's a remedy for injured workers when they're injured at work and they're retaliated against. And maybe we can just talk about that a little bit now, Seth. What is 132A? What does it do for an employee? Why is it important that it be considered?
Okay, so a 132A labor code claim is a remedy for an injured worker that can be brought either in the workers' compensation arena or in the civil arena, and it's to stop employers for discriminating against injured workers because they filed a workers' claim or because they made it known that they were going to file a workers' compensation claim. And by discrimination, that's a hard standard, or it has become a harder standard in workers' compensation because the injured worker carries the burden to show that the employer treated the injured worker differently specifically because of the injury. And many times it's obvious where you have an employee who's maybe hurt on a construction site and they're going to be building 6 schools, and halfway through the first school, the employee who's maybe a laborer claims a back injury, and he goes out on workers' compensation, and then they heal him, and so he's ready to go back to work after 6 months, and then the employer says, oh, we don't have any more laboring work, and now you're fired.
If there's 132A, there's an enhanced remedy. There's more money the employee can get if they're retaliated against or discriminated against because of the work injury, right?
That's correct.
And what is that additional remedy?
So those additional remedies can be up to $10,000. The employer potentially, I rarely see this, the employer could be referred to the district attorney's office for prosecution for a misdemeanor. There's reinstatement of back wages and back benefits. Those are all available to the injured worker, as well as the monetary penalty. And very importantly, there is an increase in benefits by 50%.
And again, this probably doesn't equal $500,000 or $600,000 if you're fired because you have a work injury that you're going to heal quickly from. If your employer has 20 employees and fires you for a work comp injury that gets better in a couple weeks, there's just 132A, which are these enhanced remedies, but they're not on the level of having these big-time wrongful termination cases like I might have. So you've been listening to the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC. I'm Karl Gerber. Please call me at the office for legal problems about work, 877-525-0700. That's 877-525-0700. For a real work lawyer, 877-525-0700. We'll be back in a minute.
There's overtime and bonus opportunities galore. The young men like their money and they all come back for more.
Since 1993, the Employment Lawyers Group has been a results-oriented law firm whose goal is to get the client what they deserve. They've represented thousands of California employees who've lost their jobs, been sexually harassed, subjected to employment discrimination, or were owed wages on an individualized or group basis, such as a class action. They have a high rate of success. There are few situations involving employment law that they have not confronted. At the forefront of employee rights, they're often the first employee law firm to confront a new legal issue. For an experienced employment lawyer, call 877-525-0700. That's 877-525-0700. They have call takers standing by. Online, read more about the firm at employeelawca.com. They have offices throughout Southern California. Make your work problem theirs to solve.
When your drains are clogged, your sink's backed up, your toilet's on the fritz. And when you need a plumber now, just simply call Ritz. We're master plumbers, we're really nice. We're big on service, not on price.
Call Ritz Plumbing at 888-757-RITZ. There are no rooter guys here, only full-service professional plumbers. You got a kitchen or bath problem? Need an earthquake valve installed? How about a tankless water heater? Well, Ritz Plumbing specializes in trenchless sewer repair, drain cleaning and maintenance, and yes, even rooter service, plus 18-month interest-free financing is possible. So call Ritz Plumbing, 888-757-RITZ. Ritz Plumbing. They're the real thing, only full-service professional plumbers, and here comes the clean pipe chorus. Hit it, guys.
So when you need some plumbing in California, yeah, simply call Ritz. Don't flush your money away. Ritz.
Ritz Plumbing, 888-757-RITZ.
Talk Radio 790, KABC News Update. I'm Steve Cumming. The New York Times is reporting that the same Russian military intelligence service now accused of disrupting the 2016 presidential election may also be responsible for the nerve agent attack in Britain against a former Russian spy and his daughter. British investigators believe the March 4th attack was most probably carried out by current or former agents of the service known as the GRU. British officials are now closing in on identifying those individuals. And Anaheim Ducks goalie Ray Emery died in a swimming accident this morning in his hometown of Hamilton, Ontario. His body was found early this morning after a report to police said a swimmer had gone underwater near a pier and didn't come up. He was 35. An autopsy is pending. KABC SoCal weather, mostly clear this evening, then areas of low clouds and fog overnight with lows in the mid-60s to around 70. More news coming up and continuous coverage on KABC.com. I'm Steve Cumming, Talk Radio 790, KABC News.
If you plan to enjoy your lawn this summer, remember, so do bugs. Change their plans with Roundup Bug Destroyer from the Home Depot. And right now, save up to $20. Bug Destroyer kills over 100 kinds of insects, even grubs and ticks, and keeps killing for 3 months without harming the lawn. It's a long summer. Better plan accordingly. Right now, when you buy more, you can save more. Up to $20 on Roundup Bug Destroyer. Only at the Home Depot. More saving, more doing. Selection varies by store.
Diabetes, high blood pressure, anxiety meds, everyone's on them. If you're a 50-year-old male, maybe a bit beefy, or even with type 2 diabetes, $1 million of term insurance may only cost you about $200 a month. Affordable term life insurance is out there. Call Term Provider and speak with Big Lou at 800-481-1458. 800-481-1458 or visit biglou.com. Remember, Big Lou's like you. He's on meds too.
Shift work.
Talk Radio 790 KABC. You're listening to Karl Gerber, workplace lawyer, heard every Sunday from 7 to 8. I'm Karl Gerber, a real workplace lawyer. In studio with me tonight is Sef Krell, a workers' compensation specialist who works in Encino. Sef, you've been doing workers' comp a long time, and I want you very briefly to tell us about an interesting case, one you think the listeners are going to want to hear about.
Okay, given the nature of this show, I have an interesting case.
Please.
So I represented a man about 15 years ago. He worked at a pharmacy in West Hollywood, and he had worked as an adult male film star.
Not Remus Helms.
Not Remus Helms, but same train of thought here. And he was recognized by his coworkers and constantly harassed at work because of his past. Anyhow, he had other medical issues. It turned out he had a seizure while at work. And when he had the seizure, he struck his shoulder and his head up against one of the desks at work and then fell to the ground. And so we filed a claim for him regarding his shoulder. And additionally, one of my colleagues, before I knew you, took on his civil case against the employer for the discrimination and the hostile work environment. And a big difference between workers' comp and civil was that they followed him. The insurance companies followed him. The civil insurance companies followed him. They followed him to
surveillance.
They did surveillance at an adult sex convention in Vegas, and they caught him, or they got footage of him using his shoulder and his arm in a way that would otherwise have been impossible considering the injury.
Now, with this surveillance, was this videoed?
Yeah, they had video of him basically dancing in a cage above the floor.
Oh.
And some of that evidence turned out to be pretty...
That could be played at the workers' comp trial, I guess.
It could. I think the difference between workers' comp and civil was workers' comp is a little bit more collegial, not as rough in terms of litigation. And the civil case was dismissed, but I was able to, because some of the factors in workers' compensation unrelated to the film, I was able to generate a recovery for him, but because it's a different standard.
Well, that's good. You know, some of these civil cases, near the end of one of these trials, you get a witness that's just sitting there and you don't know what they're supposed to testify about, and they're an impeachment witness. And I usually have a lot of fun with them, and I impeach them. I had one that photographed my client limping, and she had, leg injury. That was the disability, but it showed that she could barely walk. And this guy is playing this tape, for 20, 30 minutes. I start having it rewound, and I start, is that a limp you're looking at? So sometimes these surveillance things, if you're a good lawyer, you can turn it around. But obviously, if you're making a claim, you can't move much. You don't want to be dancing at a convention. The other thing I'd like to ask you about is, why do you think there is such a high incident of claims in the government? Why are there so many government workers filing workers' comp claims?
Well, in particular, I think lately there have been a lot of exposés and articles, investigative reporting regarding government employees, peace officers, firefighters who are bringing a lot of claims. And the reason why it appears as though they're bringing more claims is because certain claims that they have are presumed to be related to their work or arising out of their work, like firefighters, if they get a presumption for certain types of cancers, or police officers can get presumptions of injury for certain types of heart trouble. And so over the many years of doing the type of work that those people do, it can over time lead up to multiple parts of your body having little small injuries, which you may claim at the time, but the aggregate or the cumulative effect of the heavy work that, let's say, peace officers and firefighters do will ultimately, after a 25-year career, coalesce into real long-term injuries that need to be developed and for which those people who've put in all that time and all that hard work should be compensated.
Do these peace officers get a different disability rating for each body part they're claiming is injured?
No, the disability ratings are standard. The workers' compensation system uses the same disability and impairments based on a schedule that is put out, but how the schedule is applied, it is applied differently depending on your age and occupation. If you're doing physical work, for example, like a peace officer or a professional athlete, if you had a physical injury to your back or your neck, there would be a greater amount of disability than, let's say, if you were a clerical worker.
There's something called an AME and IME. AME, I think, is agreed medical exam. IME is this independent one by some neutral person, allegedly. Those are very important in workers' comp. Did those provide these disability ratings?
Yeah, that's correct. So injured workers have to prove up their cases by medical evidence. You can't just come into court and testify regarding your injuries. Medical evidence are the best source of information and the best source of proof regarding an injured worker's condition and their disabilities. Injured workers usually are inclined to use neutral doctors, what we call AMEs, agreed medical examiners, and insurance companies, I could say, as a rule, have mostly adopted QMEs, qualified medical examiners. Those are state doctors who are conducting medical legal evaluations in order to determine impairment.
Do all these doctors come up with a percent of injury for the body part?
They're supposed to. That's their
How do
job.
they know how to do that?
Many of them could be better trained, certainly, especially they could be more trained to look out for the injured worker as opposed to the insurance carrier. But there's a book, the AMA Guides, American, it's the 5th edition, and it lays out for each part of the body the types of impairment that an injured worker will have depending on their injury and their lack of recovery therefrom.
Does that book say how much the injury would be worth if there's a certain percentage?
No, the book helps the doctor to determine the percentage of impairment. After the percentage of impairment is assigned by the doctor, then a series of formulas are gone into so that at the end you obtain a rating, and the rating translates to a percentage of disability, which the legislature has determined the dollar amount.
Is there any way that an average person could figure out what amount of money a certain injury would be worth under these tables?
I think that people could look at the information but wouldn't have an understanding of how to achieve that result. They wouldn't be able to relate, let's say, the loss of a pinky to a dollar value based on the book. They wouldn't realize, well, maybe if I lost my pinky, it might only be worth $5,000 or $6,000, but they don't realize that the loss of a body part would be considered potentially a catastrophic event for which they could file an additional claim, a psychological claim, to recoup additional dollars. And certainly insurance companies are for-profit entities, and they're not inclined to explain to injured workers how to increase the value of their cases.
Other than what I sometimes hear as a first aid injury, would you ever advise a worker to try to handle a workers' compensation case on their own?
Well, I would say generally probably not. We work on a low commission. It's only 15%. So if an injured worker has a run-of-the-mill back injury where they're going to get some treatment and return to work, most of the time an insurance company doctor is going to say, hey, you don't have any disability, and they'll get zero, whereas perhaps, or more likely than not, if I were to help them or another injured workers attorney were to help them, then they would be able to get a fair measure of the disability. Let's say it's only as little as $12,500 or something along those lines, but for my 15%, it's well worth their time to allow me to handle all of the ins and outs, deal with the insurance company, and maximize the recovery.
I get a fair number of calls every week where it's someone who hasn't had a workers' comp lawyer, and the injury was some years back, and they still haven't been to a doctor, the right doctor, and That's one problem I see. I also see them just being. I honestly, I don't think an average person could handle the workers' comp process. There's paperwork, there's stuff. They just don't seem to be progressing in the claim. They're still at some point 3-4 years into this where I feel like someone like Sef had the case, the thing probably would have been over with.
Insurance companies have affirmative obligations in workers' compensation to provide benefits to injured workers. That, in my opinion, is contrary to their interest to generate profits. So why are they going to advise injured workers how to properly prosecute their case to get the maximum benefit? It seems like it's an inherent conflict of interest.
Are there large workers' compensation and settlements or trials out there?
Absolutely. For catastrophic injuries, there are significant recoveries. We have had at my firm very significant recoveries for people, multi-million-dollar recoveries for people who have had significant injuries that needed lifetime care.
And can the workers' comp lawyer help the employee figure out how to get lifetime care? And is that something they may not figure out on their own?
Complex catastrophic cases where the injured worker is going to need lifetime care, those are always complex, and the legislature has adopted more and more hurdles for people with catastrophic injuries to get the type of care that they need, particularly through the recent adoptions or it's not a recent adoption.
So we're going to have to break in a second. I want to talk more about catastrophic injuries when we come back. I want people to know what this is. It is important that you know you're listening to Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC. For cases, call me offline, 877-525-0700. 877-525-0700. For a real lawyer, 877-525-0700.
There's overtime and bonus opportunities galore.
The Employment Lawyers Group is a results-driven law firm whose goal is to get the right result for the client. They have represented employees with a high rate of success since 1993 throughout the state of California. They're only paid and if they are able to collect money from the employer, so there's not any upfront fees or costs in order to hire them. They have represented thousands of employees who've been terminated from their jobs, sexually harassed, subjected to employment discrimination, or are owed wages in an individualized or group basis such as a class action. Call 877-525-0700. That's 877-525-0700. They have operators standing by. They can also be reached at employeelawca.com. They have offices throughout Southern California. Hire them and make your workplace problem theirs to solve.
That dollar in your pocket, it's worth more than you think. Because at Wendy's, $1's all you need to pick up the new Buffalo Ranch Crispy Chicken Sandwich. Hey, you deserve the most bang for your buck. Now you got it. Hot, crispy chicken topped with melty Monterey Jack and creamy Buffalo Ranch sauce. With this much flavor in one sandwich, $1's worth more than ever. The $1 Buffalo Ranch Crispy Chicken Sandwich. More flavor, $1. For a limited time at Wendy's.
At participating Wendy's, price and participation may vary in Alaska and Hawaii.
Say no to rising prices. Amazon is raising its Prime membership price from $99 to $119 for free shipping. Walmart offers free 2-day shipping with no membership fee. That's $119 back in your pocket. What would you do with it? Go to WalmartFreeShipping.com for the chance to win a $119 Walmart gift card. That's WalmartFreeShipping.com for complete rules and details. Walmart, 2 business day shipping. Minimum $35 order. Restrictions apply. Say no to rising prices. Amazon is raising its Prime membership price from $99 to $119 for free shipping. Walmart offers free 2-day shipping with no membership fee. That's $119 back in your pocket. What would you do with it? Go to WalmartFreeShipping.com for the chance to win a $119 Walmart gift card. That's WalmartFreeShipping.com for complete rules and details. Walmart, 2 business day shipping. Minimum $35 order. Restrictions apply.
If you plan to enjoy your lawn this summer, remember, so do bugs. Change their plans with Roundup Bug Destroyer from the Home Depot. And right now, save up to $20. Bug Destroyer kills over 100 kinds of insects, even grubs and ticks, and keeps killing for 3 months without harming the lawn. It's a long summer. Better plan accordingly. Right now, when you buy more, you can save more. Up to $20 on Roundup Bug Destroyer. Only at the Home Depot. More saving, more doing. Selection varies by store.
You're listening to Talk Radio 790 KABC. This is the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, workplace lawyer. With me is Sef Krell, a workers' compensation specialist. As you might tell, there's signs out there that say I'm an expert on employment law. I am an expert on employment law, but I'm not an expert on workers' comp. I know enough about it to deal with the case with Sef Krell and to have him really do the expert stuff on those workers' comp cases. There's a lot of crossover in the cases I have because if someone's disabled, they may have a disability because of an accident at work, and then it becomes a disability under what a lot of people know as the Americans with Disabilities Act or the Fair Employment and Housing Act. One of the problems I see with these disabilities is you get these restrictions from a doctor, which are very difficult to accommodate. And if that happens, every hour you have to sit down for 15 minutes, something like that. What can the employee do if they get a restriction like that, Seth?
So obviously for the employee, that can be very challenging and devastating in that the doctor may give restrictions that exceed their employer's requirements for work. I can think of, let's say, licensed vocational nurses, people who work in nursing homes. They're often getting hurt moving heavy patients. They get a back injury, and then after they've been off
lifting restrictions,
right? They get returned to work with, let's say, 20 or 30-pound lifting restrictions. You can't transfer patients from bed to wheelchairs and so forth. And then it becomes a real problem for the injured worker because many years ago, we had a vocational rehabilitation system that provided for benefits for injured workers, money for injured workers while they were going to school to learn a new trade or profession. And now the injured worker, if you cannot return to work, you simply get a supplemental job displacement benefit. We call that a voucher, which is it's a non-cash benefit you can take to a vocational school or approved university, and you can merely transfer over that voucher for up to about $5,000 worth of tuition and another $1,000 worth of miscellaneous goods and services, or even some of that comes back in cash, but that's capped at
But what do you do if the doctor's you can't lift more than 5 pounds and you're a nurse? Can you get the doctor to change it? And if you do, is that really legitimate?
Well, there's two ways to go about that. I think anyone that comes into my office wants to be better, wants to go back to work, and wishes they didn't have an injury. So we're always focused on that first. But the reality is that many of the people that come into my office are there because they know they're too disabled to return to work. And then the question becomes, does our workers' compensation system provide them with a fair amount of, quote, compensation, the amount of money? And if it doesn't, then I have to take, depending on the injured worker, I may have to take extraordinary steps to prove up their disability to be far in excess of the standard disability, and that requires hiring expert witnesses who will write reports and offer testimony about the individual's inability to return back to the workplace.
Is this a catastrophic injury, and what is a catastrophic injury?
So you've got two types of catastrophic injuries. A good catastrophic injury, I think, would be a nurse. I represent a nurse now. She had been maybe in fast food, then as a teenager, then she got a career in nursing, is making $80,000 to $120,000 a year, works for 15 years, slips and falls in the parking lot, suffers a neck injury, let's say, and then becomes addicted to opioids treating the neck injury. Now she's a drug addict and she has a big neck injury and she can't go back to work making $80,000, $120,000, but the value of the case could be as little as $80,000 or $120,000.
So what does she do?
So she hires a vocational expert, and a vocational expert provides testimony about regarding her earnings and her inability to return back to the open labor market. And in that case, she would have a catastrophic case. She'd be entitled to the value of her lost time for work or temporary disability for her whole life. So you're talking about a case that could be worth, in workers' comp, catastrophic cases for people that are not in wheelchairs or unable to care for themselves are probably $2-3 million cases.
Wow. That's one if you want to contact us off air, 877-525-0700. Both of us do very serious cases. We're experienced lawyers. We didn't just start doing this yesterday. So if you've got, real case where you're fired, sexually harassed, or it's a workers' comp case, you should call me at 877-525-0700. Once again, 877-525-0700. I've had cases, I've had a lot of them where they're calling and they're talking about what Seth is saying. It's a catastrophic injury. You're never going to go back to work. And they don't have a lawyer, and I just don't get that at all. But, you know, I don't know what's going on there. And I know some of these cases can go on for a while, too, and these people, they need to stick with the lawyer. I know that there were a lot of changes to the workers' comp system in 2004, and I'd like you very quickly just to tell us how that's changed to practice and what those changes are.
The biggest change in 2004 was the limitation on the ability to file psychological claims. And psychological claims are important in that you could have more than one type of claim. One could be a physical injury claim, the other could be a psychological claim, and psychological claims were really limited to being filed prior to being terminated, or you had to have a period of employment that was longer than 6 months. Also, the doctors were significantly for lack of a better term, regulated in 2004.
How are they regulated?
In the way that they're able to receive compensation for the services that they provide to the injured worker. The legislature decided that the value of services had to be reduced.
Psychological claims can still be brought, right?
Yeah, absolutely. Psychological claims can still be brought for things like hostile work environment, touching.
What if you have lost a limb? Can you bring a psychological claim for that, or is that just part of the physical claim?
No, that's a fine line. What we call derivative claims that arise out of physical injuries, the legislature has precluded those. However, claims, there are exceptions for catastrophic injuries. Something like an amputation would be considered a catastrophic injury, and it would be, in most instances, allowed for a psychological claim to be added to something like an amputation.
There's a case that came out not that long ago where someone actually tried a FEHA claim, and the Workers' Compensation Board, they didn't try as a FEHA claim. They tried the same facts. And the Court of Appeals said that unfortunately that case had already been tried. They picked their court, so to speak. They picked the forum. And so the FEHA claim could not be brought. And that's something, again, I think it's very important that the workers' comp lawyer and the employment lawyer are working hand in hand on this, because they've got to decide, do you want this sexual harassment case essentially tried before the workers' comp board or not?
Our workers' comp judges are generally considered, in my opinion, to be more liberal than not. There are labor code sections 3202 that say that doubts are supposed to be resolved in favor of the injured worker. So I like the idea of bringing those types of claims in front of the appeals board as a primary avenue to prove up your case, if you will. The only downside to it is perhaps some of the laxness regarding admissibility of evidence, things like hearsay evidence.
But is somebody going to get $300,000 or $3 million for conduct that's essentially race or sexual harassment in the workers' comp board?
So for straight psychological injury claims, let's say like harassment, no, their likelihood of getting a total disability award is probably not that great. We use a standard of impairment also for psychological claims, which is based on interviews by the doctors as well as medical testing that the doctors do.
So we've been talking to Sef Krell on the Karl Gerber Workplace Lawyer Show. This is KABC, the 790. This is Talk Radio. We've talked about the overlap between what I do as the discrimination lawyer, the wrongful termination lawyer, and the workers' compensation lawyer. It's very important that the two work together. You got to decide where you want your forum. I'm not going to recommend somebody try a sexual harassment case in the comp board if the case is worth hundreds of thousands of dollars, $1 million. You can't get punitive damages in the comp board. I'm going to also want to have someone get some remedies, though, if they are fired because of a short-term injury and they don't have family medical leave and it's not a disability, it's a short-term injury, they need to pursue those workers' comp remedies. They can't just decide it's a bad thing and I don't like the system and all that. So call me off air about a real employment case at 877-525-0700, 877-525-0700. Once again, 877-525-0700. The Karl Gerber Workplace Lawyer Show is heard every Sunday night on AM 790 from 7 o'clock to 8 o'clock. So I hope to have you back next week, and we'll be talking to Remus Helms' brother.
Made on the job, get paid with flesh and blood, and it's go boy.
Join 790 KABC for the 25th annual Glendale Cruise Night, Saturday, July 21st.
Come on, baby, give me some details.
Over 300 classic cars on display, great music, and a fireworks spectacular.
Cars, music, fireworks, I'm there.
It's the best car show event of the year, and it's all free. The 25th annual Glendale Cruise Night, Saturday, July 21st on Brand Boulevard, right in the heart of Glendale. Cruise on over to KABC.com for more details.
This show furnished by Karl Gerber and Employment Lawyers. 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 By Karl